Hello friends, Namaskar. Myself is Dr. Soni. In today's class, we will discuss about section 483 of BNSS. At inception, we will discuss the topic in general way, and later on I will emphasize on the statutory provision so that efficiently you could understand the subject without any worry or anxiety. Section 483 of BNSS basically deals with the special power of Honorable High Court or Court of Session to grant bail. The said section corresponds to section 439 of CrPC. The said section empowered Honorable High Court or Court of Session to grant bail to any person accused of an offence and in custody. If the accused is not in custody and inter alia he requires bail, then he has to apply for the anticipatory bail. For that particular scenario, you may peruse section 482 of BNSS. Apart from that, the said section also allows Honorable High Court or Court of Session to impose, set aside or modify bail conditions as inter alia imposed by the concerned magistrate. So basically we have to understand the key feature of section 483 of BNSS. Number 1, it inter alia empowers the Honorable High Court or Court of Session to release the accused on bail. So basically it is concerned with the power to grant bail, but the said power could be exercised by Honorable High Court or by Court of Session. As far as the Court of Magistrates is concerned, for which we are already having two sections. Number 1, section 478 of BNSS, it is concerned with the bailable offences, and section 480 of BNSS, it is concerned with non-bailable offences. Number 2, the concerned High Court or Court of Session can also impose any condition as think fit. They may also impose condition specified in subsection 3 of section 480 of BNSS, and apart from that, they could also modify or cancel the existing bail conditions set by the concerned magistrate. Number 3, in certain cases where the offence could be tried by Court of Session only, in that scenario, and apart from that, even though the case could not be tried by Court of Session, but it is punishable with life imprisonment, the concerned bail application notice is required to be given to the concerned public prosecutor before deciding the bail plea. And apart from that, the said protocol is also applicable to the offences under section 65 or 70 subclause 2 of BNSS. As we know that as far as the protocol of anticipatory bail is concerned, it is not applicable for these offences. Point number 4, the High Court or Court of Session can direct the arrest, even could direct the commitment to custody of a person who has been released on bail under this chapter. And apart from that, the Honorable High Court or Court of Session can cancel the bail granted to the accused person if the concerned accused violates the bail condition, and we could say that the said protocol or power is similar to section 439 subclause 2 of CrPC. So in short, we could say that the said section inter alia provides a broad framework for the High Court or Court of Session to exercise their power regarding the bail, ensuring both the protection of accused right and interest of justice. Now we are coming on the statutory provision. For this we have to open the Barrett, and now I am going to explain section 483 of BNSS. Basically the title says special power of High Court or Court of Session regarding bail. Subsection 1 says that a High Court or Court of Session may direct. Subclause A says that any person accused of an offence and in the custody be released on bail. The court, while releasing the accused on bail, may impose such condition as think fit. It may also impose condition of nature specified in subsection 3 of section 480 of BNSS. And clause number B says that any condition imposed by the magistrate while releasing the accused on bail could be set aside or modified by Court of Session or High Court. And basically we are having two provisos attached with subsection 1. First proviso says that provided that the High Court or Court of Session shall, before granting bail to the person who is accused of an offence which could be tried by the Court of Session exclusively, or which although could not be tried by Court of Session but punishable with imprisonment for life. In that scenario, the concerned High Court or Court of Session shall give the notice of application for bail to the public prosecutor before deciding the bail plea. But the said requirement could be dispensed with if, for the reasons to be recorded in writing, Honorable Court is of view that it is not practically possible to give such notice. But in the practical sense, while deciding the bail plea, as per the protocol of section 483 of BNSS, the concerned public prosecutor is required to be heard. As far as the second proviso is concerned, which says provided further that the High Court or Court of Session shall, before granting bail to a person who is accused of an offence which is triable under section 65 or under subsection 2 of section 70 of Bharatiya Nyaya Sanhita, give notice of application for bail to the public prosecutor within the period of 15 days from the date of receipt of notice of such application. So basically in both cases, means the offence which could be tried by court of session, the offences which are not tried by court of session but punishable with life imprisonment, and apart from that the offences which could be tried as per the protocol of section 65 or subsection 2 of section 70 of BNSS, the consent notice for bail is required to be given to the concerned public prosecutor, otherwise the bail judgment would be illegal and would vitiate the proceeding. Subsection 2 says that the presence of informant or any person authorized by him shall be obligatory at the time of hearing of application for bail to the person under section 65 or subsection 2 of section 70 of BNS. So basically we could say that subsection 2 entirely imposes a condition to hear the concerned informant, means the victim, before deciding the bail plea, but it is applicable concerning the offences under section 65 or section 70 subclause 2 of BNS. BNS means Bharatiya Nyaya Sanhita. Now we are coming on subsection 3. It says that the High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to the custody. So basically it is concerned with cancellation of bail. So whenever we have to move for bail, we have to apply as per section 483 subclause 1 of BNSS, and apart from that, if you are the victim of the concerned offences under section 65 or 70 subclause 2 of BNS, in that scenario the concerned victim has to apply as per the protocol of section 483 subclause 2 of BNSS in case the concerned victim is not arraigned as a party, and apart from that, if bail is granted and concerned accused violates the bail condition, in that scenario the concerned prosecution could rely on subsection 3 that says that the High Court or Court of Session may direct that any person who has been released on bail under this chapter be arrested and commit him to the custody. So basically we could say that the said section correspond to section 439 of CrPC, and apart from that, as far as subsection 3 is concerned, it corresponds to section 439 subclause 2 of CrPC. So I think that I am totally able to cause all of you to understand the basis of section 483 of BNSS regarding the bail plea. If you have any query, feel free and inter alia mention same in the comment box. I will try to answer them as per my capability, and see you in the next video. Till then, Jai Hind, Jai Bharat.